Okay, so welcome back now. Dr. Farijan still leading all of us on finding out what's happening as far as his interpretation of overvoting and other issues are concerned. We saw a couple of objections, one overruled, one sustained. We'll have some understanding to that pretty shortly. You have just joined our continuous coverage of the election petition hearing at the Supreme Court. We are taking a break next hour, so they will show up. That's what we were expecting, but within that period, we'll try and fill in the time and explain issues as best as possible. We will be coming to our studios here, just in, let's say, introducing to you those that we have brought in here to help with our discussion. We've got a real full house today. We'll do some few minutes, take a break, and then come back. But there you are. We have George Wayo, Tete Wayo of the NDC, and then also here with us Dr. Maurice Ampa, also a legal practitioner, and then Gary Nimako Mafo, who's with the NPP. So we've got NDC, NPP, and then we've got Dr. Maurice Ampa here, and we're having engaging all of them in the course of time. Today we've got all of them here to help with our discussion. As we know, it's really taking a different dimension altogether with Dr. Farijan in the box. Gentlemen, you're welcome.
Thank you.
Why are the ladies in the legal fraternity? Okay, so once again we say thank you, and then Doc, let me give this to you. It's been Dr. Farijan today. Very thorny issues come up to do with his interpretation of overvoting and a few other issues. But then generally, before maybe we touch on those particular items, generally, how has he fared?
So far, so good with Farijan. Very competent witness, of course. His demeanor is very good. He's showing much confidence. He's throwing more light. And you realize that he's trying to make things somehow uncomfortable for the petitioners. He's being so competent, straight for point, and he's trying to attempt to destroy the petitioner's case. And they are feeling very, very uncomfortable. If you look at the demeanor of the petitioner counsel, the legal team, they were somehow uncomfortable. Then they have been very uncomfortable because Farijan evidence is so precise, to the point. And the last one, that is the issue of the verification analysis that he has done. You realize that the petitioners' council, led by Philip Addison, could not stand it.
You mean the one to which he raised an objection?
Yes.
Which was sustained.
If that one were to go through, I'm sure there will be a lot of people who collapse.
And so, what's contained in that? You see, we should have spoiled the case for the petition.
The issue is that the petitioner case is that people voted without being verified. Then the man said that if you have said so, we've looked at the pin sheets. Now we've called for the machines. We have done our own checks, and we have come out to find out that really what actually happened was that everybody voted and everybody who voted was verified. So if that evidence were to go through, then that category
would have lapsed.
Yes, because in cross-examination, if you ask pin sheets, Farijan will say yes, the pin sheet says so, but our also analysis says something different, and this shows what actually happened on the day. So you realize that it's a big blow to the Electoral Commission and Kwashiadan. It's a very, very big blow. It has once again strengthened the case of the petitioner, and I'm sure they'll go hard at on that category. That's actually what happened.
But why would he reject it?
Simple. I think the Supreme Court judges look at this. One, authenticity. Where is the document coming from?
From the EC.
EC, one-sided. You see, when there's a challenge, I believe that what the EC should have done, I don't know whether this evidence was taken after the petition have submitted all their papers, affidavits, and everything before this background checks was done. But if you want to be fair, what you should have done was to call for, before calling, you invite the representative of all the various parties that look, come together. Or if you make an order, come and ask a leave from the court that you want to do this. Therefore, the court will order the representative of the parties to come and then physically let's go and then get all the biometric machines, and then together, like as they are counting the pitch sheets. Then, but we have a situation whereby the EC alone, people have really doubt as to your credibility. The petitioners are doubting your credibility. They are doubting that you have allowed people to vote without verification. Then you alone, somehow, mostly decides to go and do your own homework, and then come and then surprisingly in law spring a surprise on them that look, even you said the people voted without verification. We on our own, we have this. Now you did not attach it to give them further.
So this is a surprise. It's an ambush.
Yes, so it's an ambush. And then secondly, it's the authenticity. And then I think the Supreme Court took the position that it will be unfair because the petitions have closed their case. So when you bring this new evidence, how are they going to address it? So I think that is the position of the Supreme Court judges, and I think Afraja was not lucky this time.
So it means it's late for them.
Somehow it's late.
They can't even seek leave to go do that.
Rejected, and you know how they rejected this thing. Big. So you can't bring it back again.
You are happy.
Oh, Henry, it's not about we are happy or we are not happy. You see, we are dealing with civil litigation. Civil litigation is regulated. I've always been made to understand. You see, we're dealing with pleadings. This is a matter where clearly they were served with affidavits way beforehand to enable them answer. If you are giving affidavit, you should anticipate the kind of questions your opponent is going to bring. You should anticipate it. So, I mean, they have filed their responses. In their response, they didn't plead it. Once you don't plead it, you can't lead evidence on it. It's a simple matter. You didn't plead it, you cannot lead evidence on it. You see, don't forget that the court have allowed some of these things to go in, in the interest of justice. But for now, the court said no. You did not plead it, you can't lead evidence on it. Because the test for admissibility is relevance. But where you are bringing in a document, where at the end of the day, that document will spring a surprise on the opponent, or its predictive value will be away by its prejudicial content, or to spring a surprise on the other party, the court will not allow it. Even though that evidence, more obviously, maybe it could be admissible.
I'm sure you were praying.
Understand? No, I mean the court.
Because my doc said if really that had been admitted.
No, but
you see, this
is a document which the EC itself say that they have done. How did they do that one? They themselves sat in their own offices and did it. How did they do it? You see,
they called for the machines and got the information from
the point I'm making is that civil litigation is regulated. You cannot just come in and spring anything. We don't do it like that. You must plead and prove your case. It should be on a document so that your opponent will know beforehand what he's going to face. You don't just come to court and then behind the scenes just go and bring a document and look, it's a document I'm bringing. I want to tender the document in evidence. How? When we have closed our case already. How are you going to bring the witness? No, we can't do it like that. You see, so Mr. Farijan, it's too bad for you, but the fact of the matter is that this is a serious case which is before the court. Yes, it's before the court. And look, Henry, let us not forget that. You see, there are rules governing, civil litigation. It's not that you get up in the morning, whatever you want to do, just do it. There are rules governing the civil litigation. So, the document has been marked and has been rejected. The mark as R, rejected. It cannot go in. So they can lead evidence on other matters, but not this particular one. It's rejected. Fully rejected. Yes. That's the point.
Ras, thank you. Sorry. Sorry. So why? Tell us. What does this do to the respondent's case? Is there any way that this could be brought back, perhaps admitted, but you can ask composite questions on it necessarily?
Thank you very much, Harry, and good afternoon to your cherished viewers. I think this was just, like you said, composite. It was just an addition. It was something to re-establish and state our case the more. For the respondent, all this while, we have made our case in court. Like you said, pleadings, and the court admitted that affidavit pleading will be used in this particular proceedings. So the Supreme Court rules, and then sometimes there's High Court civil procedure rules. So pleadings, order 11 talks about pleadings, like he said, that you must plead your case, and you can't speak to it if you have not pleaded. But then, Law Kwashiaiden keeps to indicate that in part of the affidavit, the answer to the petitioner's allegation, this issue of BVD, biometric verification device, its implications or the voting of it has been pleaded. My point, I think, is that is the fashion in which it came. I'm not too sure as to what is in there from the second respondent, but then if he's saying that bit of this biometric thing has been pleaded, of which I'm beginning to believe, I'm inclined to believe same, but then how did he put it? That we will also tender, or that in the affidavit, the second respondent will maybe bring the BVD machines to state their case. That would have made it so simple. This evidence would have gone in. But I think it is not somewhere there. That is why Addison have seen that loophole, and so he's attacking it. But the issue of biometric registration and voting in Ghana, I don't think Dr. Afai-Gyan will go to court. I will not plead that in his answer. It is there. So I think we should give credit to Kwasi Aiden that he wants to indicate that something about the biometric registration, the voting, the process was pleaded. Some days ago, Dr. Afai-Gyan explained what is biometric voting in its entirety. It's a process. Registering at the registration center, getting your name in a data which is biometric, getting your picture, and then when it comes to the day of pool, you verify your finger and then you go through. It's a process. So I'm so sure that in the answer by the second respondent, there is something about this biometric thing, but the fashion in which it was brought, that is what I think Lawyer Addison has seen, and so it's attacking that the BVDs cannot come. He's only attacking the device coming. Because why? The device had a lot of information on it. Afai-Gyan just told us this morning that if you have a situation where it looks like everybody voted through the biometric fingerprint verification, or everybody at the polling station didn't go through the biometric fingerprint verification. If you, the analysis you gave on the pink sheet, if you look at how the issues were, the figures were entered, it's either way. Either everybody in that particular polling station voted through the verification device, the fingerprint, or none of them did it, and so they went ahead and then in their own constituency, in their own small town, in their own small police station, they went ahead and then voted. It could be each other way. So I'm very, very sure the issue of biometric registration has been pleaded by the fashion in which it came, and so therefore, if you didn't make express indication in your affidavit that you're going to bring the BVDs, the device themselves in court, and then more or less your opponents might think it's a surprise.
Information from that, not necessarily the devices themselves, but information pulled out.
Yeah, he was. I mean, the lawyer was on his feet. If he had gone ahead to demand, would have listened to the court on that vein. But now that he's stuck with the device, the court doesn't want the device to come. But like I said earlier, the respondent just needed the information on the device to establish the point that most people.
That would have meant thousands of devices, isn't it?
Yes, because but we look at the 400, there's already been indication that it's only 400 polling stations thereabout that took our election from 7 December to 8 December. Okay. So I think the second respondent, the EC, would have brought maybe the 400 polling station area to clarify the matter, that everybody went through the verification device.
Oh, what is he saying? Are you saying that everybody?
So Harry, no. the point is
I think that's the point that EC is making.
That there were some 400 polling stations
to do with the people voting with dials the machine. Mm-hmm. It's what they're actually attacking now, and that's why they wanted to bring these devices into proof that indeed people used them.
No, what my brother was saying that my brother was I think what they were seeking to bring was the information on the biometric verification machine, which is outside their pleadings. It's outside their pleadings. Okay. That is why the court has rejected the matter. That's a simple matter. It was not pleaded. Let's leave it at that. It was not pleaded. Okay. You see,
if it was going to help to get to know what actually happened there, why has it been rejected?
What we must understand is that the respondents were served with the petition of the petitioners before they responded. And in it, they responded. Now, when you are responding, you must respond with matters which have been pleaded. And if you have any other matter to add, you add it. What prevented them from saying that we have a machine somewhere which there is an information which we are going to rely on? Well, they didn't say anything like that. And therefore, you come to the courtroom. The court, the court is looking for facts. Facts. What really happened in the elections? What happened? Yes, if you knew that you have information on the machine to bring to the court, you must demonstrate that by writing it down in your affidavit. It's a simple matter. You don't put it there. You don't come to court. You're going to lead evidence of matters not pleaded. It's as I said. If you do so, it's a rule of law in Aboba and Adashina that if the other counsel allows you to do so, and those evidence goes into evidence, It goes in, it cannot come out. The court must take note of that one. You understand? So, if you are a lawyer, you must be critical to look at the information coming in and see that, look, matters not pleaded, you don't need evidence on them.
Okay, so yes, matters not pleaded, you cannot actually push them forward.
Exactly.
But if they so show later that, this could make a good case for us, what do you do? Even after cases have been closed, evidence shows up that will make a good case for you.
Let me be very, very fair to both sides. I think the EC, the second respondent, should sit up. The good work that the first and the second respondent have done.
Third.
The NDC
and the presidents.
And the president, their council. The work they've put into this petition. Their responses and answers. The way they've been able to marshal all forces. If you look at the work rate of Tatu Chikata, if you look at the work rate of Tonleta, they have done a good job. For only you, the easy to come and then you committed a blunder, that you have a useful information like this to damage the case of the respondent. That's an opportunity. You have in your possession all the machines. You have the capacity to conduct your own audit and come up. Why don't you just plead it? You have the opportunity. You see, so I'm sure the first and third petitioners council will not be happy. But this vital, useful, relevant information that would have damaged the case of the petitioners,
at least for that category,
you've let it go. And you've done a good job. Now you come with documents that you have not attached, and then you have not even labeled it ordinarily, and you come and say, this is what we have done. I'm sad. I'm sad.
Why?
I'm sad. No, I'm sad because you see, when you have an opportunity
to see, he's not happy. You're saying you're sad.
See, that's what I mean. I'm sad. You see, and I'm sad because you have an opportunity to damage the petitioner's case once and for all. That category. Why don't you just plead it, attach it, or find another process to bring to the notice of the court? Now, look, you are challenging this assertion by the petitioners, which says that people voted, and you want at the right time the court should make an order.
So that
yes, it's dead.
It's finished.
It's dead. You see, you could have even come to court and make an application to the court that, look, the way you counted the pin sheets, KPM, why don't you also look for computer experts to bring these biometric machines, so that at least we do an audit?
Can't that application be?
No, it's dead and gone. We are past that stage. We are past that. The court is not interested in that issue anymore. And then you've done such a damage to your own case. You see, and I'm so sad because this is an experienced counsel. And I don't know whether the first and second respondent are coordinating very well, or they are allowing the issue. Look, the issue has nothing to lose. Questioning the item, it has nothing to lose. The man is already aging, and you, when you age, your practice also, it affects your practice, stamina wise and everything. So I don't know why you should allow these things to go. And now the petitions are very somehow happy. If you look at the body language, you can see somehow happy because it's like this vital information that the court needs to confront the petitioners. Now you've let it go.
No, Morris, no, you can't add anything. You can't add anything.
I mean, like I indicated earlier, this exhibit that we needed to strengthen our case.
That's good.
But it doesn't really take away the fact that the second respondent has made the case for the first and third respondent. And as the first and third respondent, where we stand is that go out there as the second respondent, as the person who organized the election, and restate the case that yes, those who could not get to have fingerprint verification, about 400 police stations thereabouts that came to our notice, we postponed the election for those citizens of Ghana in that area to the next day. And why did the EC do that? Based on the information from the IPAC meeting. The petitioners themselves vehemently opposed that if somebody is not verified, there should be a backup. If there's no backup, we can hold on, trying to find out situations or bring out a device that will help everybody vote. And that was the conclusion at the IPAC meeting. So the EC stood by that. So on our list, or from where we stand as the NDC, we think that nobody on the record went without the fingerprint verification. Those who could not do that on the 7th of December, the provision was made for them per the IPAC meeting.
So you have made your case in that direction.
Yeah, it was just yes, to rate
that has been rejected.
Like I said,
so one weight there would be placed on it. You have made your case. As far as you're concerned, nothing of that nature took place, but the evidence has been refused. So how much weight will be placed on the case that you have made?
No, see, for instance, if you look at the area that the EC now is accepting the annulment, the 7th area, the 7 constituencies, if you look Kutre in Brekum, it was over. I mean, if you come to that's on the voting, right? It's over by 8. Look at some other areas, 1-1. So all what is being said is that if there are some areas outside the 400 polling station that Ghanaians did not vote per the fingerprint verification, there's no record on the second respondents list, because to them, those who didn't get to verify, there was a provision. The next day, 8th of December, they went in there, had a biometric device, their fingerprints were tested, and then they voted. So the second respondent is only making our case that we as first and third respondent are saying that, to the best of our knowledge, every citizen in Ghana went through it. But like Doc said, and I indicated earlier, I mean, if the EC had gone a step ahead to indicate that in court, we will prove this assertion by bringing information on the DVDs. That would have made their case very simple and straight. This objection wouldn't have been sustained.
Look, I was even sad looking at question item when Philip Addison was being assertive. Then question item came. The first point is that, my lord, this is about admissibility, but then the court will decide the weight. You see, when so let it go. Let it go in. Okay. Then the court will decide whether it's worth it. You start by this. You start by this, and you create proof for the court to reject your evidence. It means that the evidence even you are giving, you are not sure the weight that the court will attach. It should be assertive. You see, in this legal battle, it's not all about the law. Psychology. You must use psychology. You must let the court know about the relevance of it. That if the petitions are not running away from the truth. Tell the petitioners, forget about technicalities. You want to use technicalities. You are looking at what the issue of what is fair, what is just. Let's look at the truth. We are here to unravel the truth. Then you must come out to say that, look, the petition is about inquiry. We are inquiring. We are going to the truth. So let's avoid technicalities. Go that way. But you started by saying that, oh, my lord, the issue is not about the admissibility is nothing but after that the weight. Then quickly you realize that Addison used psychology. Used the way it was, my lord, and he seemed look like we are pleaded, and my lord, you can even admit this thing. You see, look, last night, I think you use your senility to shut up.
You should have heard him, isn't it?
Yes, you see, you're the senior. When you are a senior at the bar, you speak, and then you're junior, you can even speak in a way that, look at the way Tachu does it, please. What if Tachu were to be in the position of the EC? This issue, you will drag it and end up confusing the Supreme Court judges. And then they'll be divided. Maybe the team will not be 7-2. It will be 4-5. But now the person who's going to defend, I've started saying that, oh my lord, you let's admit it. But then you people will decide the way to put on it. Oh,
Henry, you see, I don't see why my friend and brother Dr. Morris is sad. You see, I don't know why he's sad. You see,
why should he not be sad?
He should be sad. You see, because litigation, the technology so-called are part of the rules. It's not just about they're all part of the rules.
I thought that the little interaction I've had with lawyers, even though it's not, sometimes it might not be in there as having been pleaded, if it's that vital to unraveling.
You see, the general rule is that documents or facts not pleaded cannot go into evidence. As a general rule, if the court in its wisdom decides that, well, we will allow you just let us see if it's relevant, we will admit it in the court.
In a few occasions.
Yes, in the court don't decided to admit it into it. That's a different matter altogether. But this stage, the court said, look, 72 rejected, mark as R. Rejected. It's as simple as that. And let's move on.
I think
please,
happy with the rejection.
Let's move on with other serious matters.
There's a case just for something to be adulterated. If it didn't go in, it's all good because the court is listening. The court knows where it's heading towards. The evidence is clear that there was nothing of such.
Okay, finish.
Let's move on to other critical issues which was raised by the electoral commissioner today. You see,
I think they've not had their take on the overvoting issue.
Okay.
Earlier he had to speak to that because he was there.
With the overvoting issue, I heard Farajan giving a classic definition to him. The definition that is classic, if all things is being equal, he actually collaborate the definition of Asedun by saying that ordinarily, when we talk of overvoting, we are talking about the situation whereby those who are entitled to vote, if those who go and vote don't exceed those who are entitled to vote and registered, that means that there's no overvoting. That is his own definition. But I realize that definition did not sit well with some of the panel members. One of the panel members, I don't know whether Bafo was like, please come back, define it. Let come again with the definition. And then he went ahead and said that it's not also comfortable with the three types of definition that the petition have given, that there are other two types. Then he went ahead and pushed it. Define what those two. Tell us why you are not comfortable with the definition of those two. Then he ended up, you realize that he could not explain very well, but then I said that he doesn't want to use the word overvoting, but what? Use the word SS.
SS vote.
SS vote. So what is SS and overvoting?
What is it?
So you realize that, as I told you, the issue of what overvoting will be a legal issue now. It will be a legal issue for determination by the Supreme Court. Because the parties are divided as to what it means. Aparija says one thing, Sedukita is saying other thing, the petitions are saying another thing. And then I'm waiting for the cross-examination where it is put to the EC at the scenario where we have people who voted outweigh than people who are entitled. How will it tempt those things when it was put to Atidikitia? And let's find out how the EC will respond. So the issue of this, I realize that the Supreme Court have made up their mind. They are going to look at the definition based on our electoral laws and maybe other jurisprudence, whether what constitutes overvoting, but will not limit it to one person's own views, like the simplicity. They will look at the context when it comes to elections.
He was talking about perhaps a redefinition of what overvoting constitutes now that we are using biometric.
Definitely, he said they said you, but the Supreme Court judges were not clear. You realize that at the end of the day, he was not able to convince them. Not all. I'm not saying that the Bafo Boni was not convinced. He said, you see, that shows that I'm not convinced. You should have come and explain what overvoting is. So it's like the overvoting has become an issue where there's doubt even as to in the minds of even lawyers. As we sit here, it's very difficult to stick your neck out and say that this is overvoting, because let's wait for the lawmakers, those who says that they are not bound by any law apart from the Constitution. They will come out, and when they define it's final.
We're hoping that we'll get that definition by the time this case closes, isn't it? Issue about overvoting.
Thank you very much. I think
you must be happy, because it looks like he's making a case.
No, because if you look at the examples given, some of the examples cited, the Kutri cited, it's eight votes. If you look at where Honorable Frida Prempe was supposed to come and testify, Tano North is 1, and the other areas in the North 1. So, which choice of words, semantics, which word would you appropriately use? SS or over? Sometimes you have to weigh and then put in the right word. Don't wear kids. Comment translator, put in the right word. It's appropriate to use the word SS, because if you have 500 people and you count and it's 501, it's just SS of 1. You understand? That is where the EC is coming from.
And that, and in the mind of the petitioners, that constitutes overvoting.
That is, if we stretch the definition outside the classical definition.
It says it's what foreign material.
Yeah, these are foreign materials.
And he also is saying what excess. What?
Yes, and those excesses are part of the foreign material. So the foreign material, in the sense that when you pick the sheet, you look behind it, and there's no official stamp of the EC. It's an excess material, but it is there.
But they are saying that has been counted as part of the votes.
That is where the
That's
problem,
what the petition.
that is where the problem
petitions
comes
are
from.
saying.
That is where the problem
And so
comes
the
from.
sorting could not take care of that. I mean, those sorry materials, sorting couldn't take them out, and they've been added as votes. That's what
Harry,
they're suggesting.
if you look on the pink sheet, some of the computation today, Afraja has taken us through some of them. There are errors on the face of the pink sheet when it comes to the analysis, the computation. So fair enough, excess material, but then you end up, even when they have been removed, you end up having a presiding officer taking 225 from somewhere and just shopping it into another box, putting 198 somewhere, and then they are not reflecting.
It's not becoming quite clear as well that training for these officials perhaps has been a bit questionable, because if you watch Dr. Farijan and how he went about the figures and the interpretation, you could see clearly that maybe that's what my mind tells me. This is a case of, or cases of people who didn't have too clear knowledge about what to do at certain points. They were putting figures there that contradicted themselves. And actually, if you sit down, you add up and you take your time a bit, perhaps you know what has gone on. And not necessarily that maybe they have deliberately done something wrong.
And to be fair to Dr. Farijan, maybe it could be so. Maybe it could be so. But when you look at the figures represented, there's a systematic trend of overvoting all over. It's not just one polling station, it's across the whole nation, everywhere. So are you saying that all the polling stations they were not trained?
And I think that
is that what you are saying?
I think that this issue about the severity of it has not really hit so much because of the numbers involved. 1, 2, 3.
No. It's the numbers. The numbers of the overvoting is the 1, 2, and 3. Whatever you're talking about. But what I'm saying is that the numerical strength of the problem is across the nation. It's everywhere. It's not just 4 police stations which are voting.
Okay.
It's across the nation. So are we saying that the police officials were not properly trained by Farijan? Is that what you are saying?
But if it's across the nation,
yes,
is it not becoming quite clear?
That is why I'm saying that there's a systematic trend. There's a systematic trend. Please, there's a systematic trend of overvoting across the nation. That is why the petitions are saying that, look, it appears that the trend was meant to facilitate or to aid one person against another person. You understand? That's why they are in court. So you see, it is not just a case simply to say that, oh, it's just the 1 vote, 2 vote, or 3 vote, whatever. They were even annulled. Vote Nairobi, those are not. 4 police, they were annulled. Swakwa, those are not. Tunnels North, annulled. Brekum. You understand? Now, at this of Afarijan, you know what he said? He said even in Brekum, the presiding officer over there annulled it before informing him. Meanwhile, earlier when he has said that he is a sole returning officer, and therefore to be able to annul, you need to express what? Authorization.
Yeah.
But you said right now in evidence in chief, that it was annulled, and then he was informed, which means that the officer used his own instructions or whatever it is to acknowledge before even informing him. In the same way, Nairobi and they were not. But he said he was not aware until the petition was filed and served on them. Then he became aware. As of now, we go to the EC's own database and they are not areas. I'm telling you, those areas are still in the database, but they were not part and counted as part of those places. They were not counted as part. So I mean, how can you come and I think that today, he's been a bit economical with the truth.
Is it not also becoming clear that election issues are very complicated issues? Initially, I was even thinking that he would fall back on records of previous elections to prove a case of most of these problems that have come over time. And I think that it's something that has been the case since the start of elections.
You said it rightly, because you realize that because this is a test case, those previous elections, we let it go. All the irregularities and the malpractices, they are all everywhere. But this one is being tested. And when you take matter to court is not about hearsay, it's not about suspicion. You go with hard court evidence to prove your case. And then court issues matters, tiny issues. You can even be knocked down by one technicality. So the issue now is that Afarijan is being called to account for details. And then you realize that he started by saying that, look, there are difficulties. He has challenges. It's not easy. He started also by laying a solid foundation, sympathy game, by saying that, look, we organize election. It's not an easy thing. We have to engage about more than 100,000 plus non-permanent staff, and you should definitely expect people not being competent enough to do the right thing. You should expect that there's no elections where you cannot pinpoint any fault. So it started on that premises. But the question is that the petitioners also are making a case that if there are errors, then the errors and those faults also led to one person winning and the one person losing. Therefore, we will not also take it as an excuse. Error. Why will not stop error? Seriously. So that is where the petitions are also coming from. So whilst the respondent and the EC is pushing the issue of, look, errors are about to happen, clerical errors, administrative errors, issues, these are not intentional, transpositional errors, errors and here and there. The petitioners are also saying that, look, all these errors add up in declaring one person a president. Therefore, the court should take it as a serious issue. That is where the dilemma is going to come. That's where the issues are going to flow from, because you have a situation whereby if you cannot explain, you use error. That's how I'm seeing it. When you see that the respondents are pushed to the wall, they said they use error. When they are able to explain, there's no error.
Is it not revealing a fundamental problem with the election system, that you don't always gets the case where all results that come from all the stations actually reflect exactly what you want?
Let me tell you something.
That in instances where you actually have to sit down, think through, do some research before you accept which results.
Whilst I was looking at Farajan, there is something that was going through my mind. This is a return of officer who I'm sure after this election, I think it's no more than electoral commission.
It's possible.
Now he's
still chairman until he retires.
Maybe in the next 4 years he will retire.
Maybe.
Then incoming new chairman will take a clue.
let's say for now. Let's refer to the institution or the electoral commission.
Yeah, the
so it doesn't
commission.
look like we are pushing him out.
You see, the electoral commission, but this election, the posture of Afarajan was like, I am the EC. You know, he was the one coming out with all the instructions.
Of course, that's
really, that is where people, me like this, I was not comfortable with him in the way he controlled himself before, not during or after, before the elections. Afarajan was more snobbish. He was more like, oh, leave me alone, we are independent. And then I said the day of reckoning will come. Now, when the day of reckoning comes, you see how sober. Now, just sitting in the courtroom, look very, very composed and very sober. Because you cannot go to the court and start throwing your hands. You know, you realize that when the issue of 32 creation of a constituency, people were if Afarajan have taken this posture of always inviting, listening to advice, bringing stakeholders openly. Not only in seminars where people don't know, but you always bring them on board. Then people will sympathize with you. But as of now, people don't want to sympathize with you. They are shifting all the blames. Now you sit there and say that, some of the cancellation you don't know. There's only one. So you look at it.
It's true. You did know.
You see,
who took the responsibility?
But it doesn't mean that
who takes the ultimate responsibility of the elections?
Facts, isn't it? If I didn't know, I just said no. I take responsibility.
He didn't know. He ought to know. He ought to know. He takes ultimate responsibility of the elections. He ought to know.
Overvoting, and the petitioners indicating that because of that, the votes have gone one side, and then therefore somebody has been declared. I think Afarajan, he's demystified that. He's answered that clearly. You have 7 constituencies complaining of. You come to the EC, you tender evidence, pink sheet. 2 constituencies, you have more pink sheets than in the 2 constituencies. 5 constituencies, you have lesser pink sheets. That is done with. Now, he's indicated that if you put all the votes together, whether overvoting, whatever, in these areas you are complaining of, they will not affect the results. There will be no rerun. Because, in fact, these are the areas that the president of the land today, John Dramani Mahama, had more votes. So this cry that because this issue of 1-8 small overvoting here put all together has given one-sided declaration, it's wrong, because Dr. Afarajan has just demystified that.
That's the case that the petitioners are making, that in most of the areas that they have actually submitted, the pink sheets have submitted to cover some 11,000,
138.
Yes, 138. These were places where the president did quite well. So he thinks, or they think, that those supposed irregularities obviously benefited him.
Harry, if you take some of the pink sheets that were used, the same thing happened on them. 1, 2, 1, 2. Sometimes clear administrative error by a presiding officer, taking one figure from here which does not even exist, chopping it down there. So in totality, even these things are in the areas, in the 11,138 pink sheets, it still come to the point that even when we do the calculation, a certain John Mahama will still get votes ahead than the person who is
that's
debating.
That's wrong.
And he's used the 7 constituencies as an example.
But they are using technicalities here.
Yes.
That as long as you have just one vote more than what should have gone into the ballot box, technically that's overvoting. And if their definition of overvoting stands, then agreements they had prior to getting into the election suggest that we'll have to annul all those things. Hence they're seeking to have 4 point something votes annulled.
No, let's go by what you just said, that 1, 2, 3 is so paramount. Dr. Farijan in the box today have indicated by using the 7 constituency as a case, the 7 that they came to the EC to complain of on the 9th of December, that when you consider all these bits and pieces here and there, a certain John Dramani Mahama still had more votes than the person in court complaining. So let's do the calculation. In fact, let's take all the votes. Let's take all the votes. Give all to the first petitioner.
You mean the excess votes?
Yes.
Okay.
Let's take all. In fact, all the votes. The areas complain.
What has led to the supposed irregularities and overvoting?
Yes.
I mean, like, want to take the 1,185.
Yes.
Put
all together and give it to the first respondent.
Okay.
He will still not get 50 plus 1.
Okay.
That is a
No, please.
That is the competition about the 50.
I think I've heard.
You didn't hear Dr. Farijan make that submission.
No, he was talking about
No.
only the annulments.
Only the annulment analysis.
That he was saying that certain 4 areas were annulled, and those areas that are annulled, there's only one that he was informed.
Okay.
And the Brikum. But even the ones that he was informed, if you take the 7, it will not change the results.
Yes.
Limit only the 7. The annulments, it will not change the results. So with the 7, even if you everything 100%, people voted 100% for the NA, it will still not give NA the 50 plus. Mamas will still win. But you realize that the issue of annulment, the petitioners are moving beyond this 7. And
they are moving to 11,000.
Yes, and that is why they are also asking that with those annulments, then the figures will change.
Okay.
You get right? Because
has anybody done that computation?
Yes, Baumia done it.
It's 1, 2, 1, 2.
You see,
Baumia 11,000.
That's the analysis.
1 vote, 2 votes. That's what there is.
Yeah, but I'm asking.
There's no one instance where you have more than 10 on those 11,000.
So let's say we put all that together. We put all that together. Has somebody done that computation? That all those figures 1, 3, 1, 6, 4, 5 put all together. What has that come to?
Eric,
how much of it?
This election was declared on a margin of 320,000 votes difference. That's what we're talking about.
Okay.
320,000 vote difference. Now you have 11,138 pink sheets. Imagine you have, let's say, 2 in each of them. 11,000 times 2. What do we get? It's not close to 320,000.
But you see,
Sovereign is using
70 point what? 7? Sorry, 50.7.
50.7.
So the 0.7. That's 11,000 or 22,000.
That's what we're talking about. Because in election, those decimal points. Yes,
so,
those decimal points in election.
What does 0.7 mean?
That 0.7, like you and I know, you and I do. I've not even done the calculation now, but that 0.7, I don't know how much vote that is going to be, but it's not a small margin. You understand? So even when we go by the 11,138 pink sheets, of which in the Supreme Court today, none of the pink sheet has depicted an overvoting issue of more than 10 votes. None of them. Others would have brought it up.
I think that's the point that a lot of us have missed here for a very long time, all throughout. Perhaps somebody should do that computation.
It will not be more than 50,000
How do you vote? Are we talking about? But obviously, that is not the case of the petitioners. That obviously is not the case of petitioners. But then, as long as you have 1 extra annul, 2 extra annul, 5 extra annul. So this all
it is the second leg of the court. The court is saying that the second leg of the court. The court is saying that. Let me just say.
You have your time.
Because the question you just asked is the second
just so that we can have some understanding to this.
The second question you asked
is evidence we have to admit.
No, because
the question you asked is the second leg. The second leg of the determination. No, if I'm right myself, the second leg of the determination. The Supreme Court is going to determine this issue on 2 principal determinations. 1, These statutory violations, malpractices, thereabout complaint, if they were, first. Secondly, if they were, did they have a bearing on the election? Can they change the declaration? And I'm saying that
I think that's
we have a declaration of 320,000 vote margin. Now you've presented 11,842. Now you said 704. You're not relying on them. 11,138. And all the pink sheets you've shown to the court in evidence, none of them has shown an overvoting of more than 10. They're in the ranges of 1 and 2, 3, 4, 5.
Yeah.
Multiply that by 11,000. You don't get to 320,000.
That's the case they are making. Yes, that's a case to be made.
Yes.
Let's put all those excess votes together and see what it will come to. But for them, it's like that is not the issue we're looking at here. As long as there's 1, 2, 3
no, but Harry,
that is what
Afrajan has used the 7 constituency logically to explain.
But that's a case for the Supreme Court to make. That's a decision for them to make.
Yes.
Gary.
Anyway, I think my brother is just missing all the entire points.
No, he's made his point.
He's missing the point. You see, he's missing the point. You see. Let's go back to the basis. We went to elections with rules and regulations, and the rules, more or less, are the terms of engagement. You understand? Now, these are that. Look, we have a voter register. If the number, for instance, is 10, and 8 people come and vote, they are verified, they vote, they go their way. Simple. Now, have a situation where people came, some were not verified, yet they voted. Again, we have an election where in certain areas the number who voted are in excess of the ballot in the box. That's overvoting. The EC comes and say, look, well, in our view, overvoting means eligible voters in the polls should be in tandem with either the ballot cast. Whichever way you want to put it, fine. But there are instances where people or certain police station people in those constituencies they went in excess of 1 or 2 and they were annulled. Now, how can you have one law and you apply it differently? Henry, you have one law. Narugu, you apply it with a stick, and you go to other places, excess of votes, you say, no, that one, I will not annul. You go to Tano North, you go there, people overvote, you annul. Even the man over there annul before even informing you, the electoral commissioner. And he didn't say anything. He said, okay. So, I mean, it's laughable. The same rule should apply universally. That is the point we are making. You cannot have one law and then or one rule then it is applied differently. It's not possible like that. It's not possible. So it's not an argument. That it just de minimis one vote. No. What is happening is that one. You see, because how? If you have applied the rule this way, in Tanonof, in Narugu, in Gamaga, whatever it is, why if you apply the same law in other places? That is the point we are making here. Are they also not Ghanaians? So you see, when we are making the arguments, we should be very clear the way we make the arguments, so people will understand what we are saying. Two, the EC boss said that he's the sole returning officer for the presidential elections. Is that not so?
It's a fact.
And that you must set assistance or authorization from him to annul the election. But what did he say himself? He said, tell enough to annul before he was informed. And what did he do when it was annulled before he was informed? Did he say they should restore it back? Or did he say, they don't annul it, you leave it there like that?
But should that really be an issue?
Because
if his consent should have been sought.
It's not consent. He must authorize you before you can go and annul.
But you have done what he would have authorized you to do.
No, wait a minute. Let me tell you one thing, Henry. The officials went into the game with clear rules and instructions from their boss. They were told that when it's in excess, you must what? Annul. Do you think that the people in Gamaga and Narugu and Apple will have just used their own authority if they were not told to do so to have annulled elections?
So where are we standing now?
What I'm saying is that yes.
Before talking to him, and then in another breath, it's like they should have done that because they had the authority.
I am not saying they should have. I am saying that the people who were there, they had clear instructions. That when you go and the votes are in excess of one, you must annul.
Okay.
Afraja himself made a press conference in this country and said,
should they have reverted to him, to seek his views as to whether that annulment should have come on or not?
Why should they refer to the man? The man,
that consent, and he did it, and he got to know later.
What consent?
Should he?
What consent?
Question. Like he said that his views were not sought. He was not. His attention was not drawn to it. He got to know after the gentleman had done it.
Henry,
you seem to have an issue.
What consent, Henry? We are going back and forth on this same matter. He himself in the evidence said that the man in Tanonoff annulled the result before informing him. He said it. All right,
and it's
which invariably means that which also runs counter with his own argument
that
the people must sought his express authorization before annulling it. But he himself said that, look, the man annulled even before informing me.
Okay.
And my question to him is that, what did he do when the man informed him that I have annulled the results?
Okay, so maybe he would have annulled it. The fact that the person went ahead before telling him, that's not necessarily mean that even if he took the right decision, you should come and cancel it.
Because my point is that my point is that the EC officials who went into the elections,
there's fire you're there with water or fire extinguisher. You need authorization to be able to do that. You didn't do that, but you went and doused the fire before telling him.
I'm telling you that the people who were there,
should your boss punish you for doing?
I am saying that the people who went into the elections, they had clear instructions.
Okay,
they were told what to do. I mean, nobody can convince me that they were not told what to do before they went into the elections, or they were not trained. They were told what to do. That is the reason why.
I'm not. That is the reason why I understand you with why he did not seek authorization. Yes, he had now.
There was no point. There was no point.
What we expecting Afarijan to do after getting to know that a person has done the annulment without his authorization.
At this stage, what he's doing now, you know what he's trying to do now? To shift blame on his officials.
Okay.
But what I'm saying is that the ultimate responsibility,
fine. Now you're putting
will lie on the desk of Afarijan, and I'm saying that look, the officials who were there, they had clear instructions what to do, because they themselves couldn't have done what they did if they were not told that look, when the thing is excess of one and all, they wouldn't have been doing it.
Okay, so you are seeing a clear case of Afarijan trying to shift blame.
Yes,
onto his
and that's why it will not wash. It will not wash. It will never wash.
No, what are we expecting? I mean, when we show up back in court after an hour, he still will be in there. He will still be answering questions. We've had one major one which we've talked about, being rejected.
I think he'll come back strongly and realize that the rejection of his evidence affected the morale. You can see, Kwashiadan changed the whole thing to annulment. So he will come out this time to address the various issues. I think he have touched on the role of the agents and then the presiding officers. He now is on a biometric verification, which they did not allow. You move on to the issue of, I don't know whether I have also touched on serial numbers.
Not yet. I think that's one of the issues that we're going to talk about. It's been broached, but not necessarily dealt with well.
So I'm sure, let's hope that he will be able to finish his court examination chief today.
So what it means in effect is that his answer or attempt to collapse the case of the petitioners on a leg of the voting without the machines also itself has been collapsed.
He has not able to. He has done a little damage, but not. He could have collapsed it, but he has been able to punch.
He's made a case against it, but he has not made. He's trying to make a case over voting now.
Yes, but now I think he will. I'm looking at the situation whereby EC this thing solicitor should finish well. In examination chief, finish well. Don't finish and allow your opponents to have more confidence. So you realize that if you look at all the lawyers, with the president lawyer finished well, with the cross examination chief Chachu finished well in examination chief. So we are expecting the EC. I beg the EC lawyer should also try. So don't try and finish well. You see, because it look as if for the past 2 days, I don't know. Every time you quite remember the last time he also did not finish well. Then they went on break.
Yes, they have.
So please, you should try and finish well, and then give the witness some confidence. Because you see, trust me, Philip Addison is going to come hard. because you see what he did to Aseduketia and then what they said Aseduketia is small. You see, because he has reserved so many ambitions for the Afarajan. He is the one who can make the petition, so he's going to go hard. They expect a lot of voice recording and video shown to weaken the man. You know, your own words against what you've said, and then they are going to push him to admit certain things. So psychologically, Afarajan should be prepared. But you see, one thing too, I want the EC, the posture of the EC, I beg in this position, as I've tried to do, is to make sure that he's a referee. You know, he should not be seen to be siding too much. He should come up and then be fair to both parties. You know,
if his views are shared by the other side.
Try as much as possible to be fair.
Okay.
You see, don't let the petitioners see you as you are not there to assist the court to unravel the truth. Like, be fair, come out and then say it as it is. But don't when it will favor the respondent, then you come out. When it's going to damage their case, then you try to shield. You should not do that. You should come out when it's going to favor each party. You are like the mother. Liz is like the mother to the two children. They are fighting. You don't have any stake. You don't have any. If any party wins, fine.
One of them is attacking you.
But definitely you have to. The attack is to improve your system, and you have acknowledged that there are problems with the electoral system in Ghana. So don't see the petition as attacking you. Come out and let's see you to be more credible in your answers. Don't try, because you see, when you try to be invasive and they catch you on cross-examination,
you will die.
You'll be in trouble. So I'm pleading. The NDC Council has done a great job. The President Council have done a great job. Easy. It's like baton. Please finish that.
Right, let me give it to you. Take a short break.
Thank you very much, Henry. All right, I think that I like it when a dog tries to come that way. At least from where I'm coming from, when he says that my senior counsel in the letter that you have done well, I think I will appreciate that. But I think that his submission on the EC is not been a bit clear, because first and foremost, our system is adversarial. You understand? There are two systems all over the world, adversarial and inquisitorial. Ghana and the Commonwealth is adversarial. The petitioners have taken the EC to court. You don't expect the EC to go in there and behave like the mother he's talking about. Like, that's why you ask him, even one of them is biting you. The petitioners are in court to discredit the work done by the second respondent. And you expect the second respondent to go in there.
So they must come out fighting, isn't it?
Not fighting, but the second respondent, all this while, has been a bit credible. Dr. Afarajan has stated clearly where he feels that there were irregularities. He said it. On the issue of presiding officers not signing, Aseduketia said that they are supposed to sign by law, but if they don't sign, it does not invalidate a declaration, the total votes that was cast and then each party getting. When Dr. Afarajan came, what he added to Mr. Aseduketia's point is, but going further, just to add the word, if they don't sign, it's an irregularity. What do you expect of the EC again? So he's been fair. He's stating the facts as they are. But so long as our system is adversarial, you take me to court. You don't expect me to come to court when you have taken me to court, seeking to discredit not only internally in Ghana, but the whole wide world. After 6 elections, successful ones, when some countries are fighting over election results, we have done it 6 times per the same structure. And you all of a sudden take me to court trying to rubbish all that the commission have done all this while. It's not fair. So I think that dog is not getting
fairness in this.
Where dog is saying that.
Where lies fairness? If someone feels aggrieved that he takes the other party to court.
So that is why I said dog should be a bit charitable with the EC, because the EC is doing the best to be neutral.
That's your case now.
So his submission that the EC, he's begging them he should be in the box and trying to be fair to both parties. It's not fair to the second respondent, because that is exactly what they are doing.
No, but that's his submission.
Just reacting.
No, I don't think you're fighting him.
I'm not fighting. You see, for example, the issue of biometric verification, when my brother from the NPP says that it is Yamutu. It is never Yamutu. It has been established that there were some 400 polling stations that did not get to do it on the 7th of December. The EC pushed it forward. It's clear. All what the second respondent sought to do was that bring those information on the BVDs to come and then re-establish your point. Like Doc said, put more weight on your case.
No, but
by
in terms of
so it has been settled.
That is, they will not get the opportunity to tender that.
It doesn't hurt. It's not fatal at all. It doesn't hurt our case as respondent, because the point is that we've already made it clear that this never happened at all, because there was a remedy to what happened a day before, and so we rectified it. We only sought to bring the information on the data proper to come and establish that. So if that is not coming through, it's not going in, it doesn't affect our case at all. So he shouldn't be deceiving himself that the issue of biometric verification is not settled. It's quite settled. The respondent have made their claims. We wanted to just come and use a certain document to establish that case. That is clear. Take the issue of the returning officer, and then the national returning officer Faija himself. He made it clear today. When it comes to parliamentary, the returning officer in the constituency is the boss, is the champion. You can go ahead.
Okay.
But when it comes to presidential, the whole country is one constituency. And so he is the boss. And you use the issue of the fire service issue. Let me link it to university administration. The VC is there. But when it comes to admissions, the registrar's office is paramount. Go through the system, get yourself into the university structure when the registrar is not aware, and you think you're in the university. When the time comes, you'll be out. So if you said that those guys who are on the ground were to move the election by rules and regulation, one paramount regulation that they know is that when it comes to presidential election, the man in Accra is the boss, and so you must seek permission.
Okay.
You must seek authorization. So if you have stayed in Narugu, Gambaga, or Tano North, and you want to use your own volition to cancel presidential elections, that is wrong. It is one of the duties of the officer to know.
I have to take a break here. I have to take a break. I give you 20 seconds.
Oh, Henry,
you have spoken. I don't know why you still want to speak. This is
Henry,
I'm betting backwards. Do 20 seconds in this. Don't complain.
Yeah, you see, if I want to take us back a bit. The EC started very well. Yeah, I mean, the last Thursday, they came admitting certain very, very important facts that yes, all the parties agreed at IPAC, and even in the law, Regulation 30, 1 and 2, that no verification, no vote, unless your hands are amputated. No verification, no vote. 2, if the presiding officer does not sign the pink sheet, it's an irregularity. These are very, very critical matters before the court. Now, the last matter, which
20 seconds, you almost.
Which I just want to touch is on. You see, I think that whether the EC will move or the EC will not do anything, whatever it is, that Farajan must come clean. Farajan's reputations are on the line. You see, he has nothing to lose because he's a referee. If two people are fighting, he myself or you are fighting, referee is in the middle. He has nothing to lose. He should come clean. His reputation is at stake, and ensure.
Okay.
That
he's still in the box.
Yes,
he's still in the box.
It's very, very important. It should be just kept clean. That's all.
Let's take a break. When we come back, and the Supreme Court still hasn't showed up, we'll continue with our discussions. Stay with us.
Business Focus on TV3 zooms in on world markets and anticipated business developments. We bring you perspective and insight to business news, plus in-depth interviews with the movers and shakers in the world of business. It's all right here on TV3. Discusses the biggest stories of the week.
Social impact mitigating levy.
Yes.
What's that?
Financing social interventions, particularly for people who will be heavily impacted by the increase in fuel prices.
Eight guests from all sides of the issues.
You are the people in governance. What do you make of the argument that has come forth?
Governance and government is different from political parties.
Look, we have laws. If we want to change the law, let's change the law.
AG is supposed to integrate or bring solidarity. Can anybody tell me when the Bible was written?
And gives in-depth analysis in his own style.
I have had the rare opportunity of interviewing a couple of homosexuals. One actually works in a high position.
Agenda every Thursday at 8:30 p.m. on TV3. It is highly dangerous and highly physical work, but they are ever ready to protect you. Experience the police in action as they go all out to ensure your safety.
Join us and learn a thing or two on the safety tips segment on You and the Police.
This program is sponsored by
Trelido, the ultimate crime barrier.
The journey is on. TV3 Mentor 7. The most electrifying and sizzling reality show is back with a fresh look. See the contestants perform to your pleasure with style and attitude. Share a breathtaking experience as you watch TV3 Mentor 7. For your favorite contestant to stay in the house, SMS the name to the short code 1738 on all networks. SMS costs 30 pesos. Join us in Studio B for Mentor live shows every Sunday at 8 p.m. on TV3. Mentor takes you higher.
All the drop and wash. The speed, the action, lovely footwork, the kick, absolutely terrific, and the goals, and beyond all reasonable doubt, Manchester United are 5 points clear tonight. And they are now literally in the shade. All on Sports Station, Mondays at 8 p.m. Sponsored by Cowbell. Only on TV3.
You're watching me. I'm coming. Yeah.
Ghana's strongest, sponsored by Vet Noodles and Atari Ginger Gin, showing on Sundays at 2:30 p.m. only on TV3.
It's time to leave the community.
I'm sweating already.
It's quite hot in here.
We are the industry's biggest event.
From Sege in the Adar West District.
Every day, our reporters travel to different places, covering tons of stories. Stories that sometimes brings us to tears and even drive society's development. Well, on Notebook every Sunday, we'll explore the lens our reporters go and the challenges they are confronted with. Join me, Bridget Otu, every Sunday at 12 noon.
Notebook. Notes from our reporters.
Why you stop this thing?
You see what you do?
Here who are helping us understand what's been happening in courts all throughout this day. George Tetewayo of NDC, I keep missing the name, George Tetewayo of the NDC, and he's a legal practitioner as well. Then Dr. Maurice Ampa, also a legal practitioner, he's been with us several times as well. Then Gary Limafuma, he's also Gary Limakumafu. Gary Nimakumafo. Okay, he's also with the MPP, a legal practitioner. So we have lawyers here. I think you're their senior, I guess.
Yes.
Okay. Okay. So let's be understanding some of these issues again. You are talking about EC. You are saying that EC should show up and be seen as trying to bring both sides together. The lawyer or to your left also suggests that the system that we operate here would not allow for that kind of allowance. It's adversarial. You must come out blazing. Somebody is taking you to court, is challenging your credibility. So many years of elections, 6 or so elections held, and today the person is saying that you've got it all wrong. So it's not time to treat him with kid's glove. You've got to go and punch hard. Is that what the system?
Yeah, you see, I sympathize with the submissions made by my learned friend. And it's true, because if you drag somebody to court and then you want to round down the person credibility is at stake, definitely the person will not be happy with you. But the reason why I'm saying that is the matter for the two political parties who are contesting, the respondent and petitioner. Because you see, there's this perception, once you join the NDC and the president to fight the common enemy, that is the respondent, the perception there will be like then will the ANC always be in bed. You get me? That's why I'm saying that you should have this thing in mind, that this is only election disputes. So you should always do things to reflect that neutrality. That look, although with this election petition, you see me here, but I'm not for the NDC. I'm not for the president. I'm for the truth. I'm for the truth. I did the right thing. That's what I'm trying to say. So where it goes for the respondent, say so. Where it goes for the petitioner, say so. That's what I'm saying. It's a difficult situation, but try and do that. It's like me sitting here right now. It's very difficult if you want to know my political color, but I voted. But I'm trying hard to make sure that I do away with my innate party perception. Try to be professional. The two they've come out and they are showing their political colors, but I have to be hard to come out. So the EC may have an interest to protect its integrity, but when it comes to the issue of trying to be neutral in this legal battle, they should not lose sight that you will always not be with the president and the NDC in every this electoral disputes. It will come to a time you may also be on the side of the MPP, because it may change. It may happen that also MPP may win and then NDC will also win. But if you always come out with your being neutral, you can always say that look, when it was for this, I said A, and then once it was still done, I'm also saying it because I'm being principled and consistent.
Okay.
That's why I'm saying that they should be very neutral in this endeavor, and then try as much as possible to always help to unravel the truth.
Gary, some have said that judging from elections, results from previous elections, this should not have been a big case at all, because there have been perhaps other issues like this, and I think parties have all agreed on how to work on it, the problems, the irregularities, and so perhaps they're pushing the EC too far.
Oh, anyway, you see, all the elections which have been conducted in this country, which of them have been challenged in the Supreme Court?
None so far.
Yes. You see, this election that we went into, Henry, it was a very serious election. The stakes were very high. You see, so if you, as a referee, as an independent arbiter between two contesting parties, or even now, I think the other parties, PPP, Indum, they were all contesting. So you, the SEC, should be the referee, the independent arbiter among all the parties. So to come out now, if you look at the way the posturing of the EC and how the case started, and the way every objection which is being raised by the first respondent is being supported by the EC, every motion which all of us have been
it's a fact, yeah.
Yes, we have been from the beginning, the very beginning of this case. Every motion being raised, supported. The way that they all agreed was when Amicus Korea came. Amicus Korea Makudi came. That one there was agreement by consensus. That the man was an intermediate, the man was there, the man, the president was fully represented.
To delink or to decouple the president from the case. You see, that Doc has told us they're actually interested parties, so it's better to be instead.
You see, to protect their interests. You see, the president ordinarily will not have been sued, but by virtue of statute, that's why he's a party. The main person in this matter is the EC. The main person in this party is the institution, is the EC as a body. If the president, has been sued in this matter by virtue of statute, and the NBC, if you say, well, we thought that we are interested party, so please, court join us.
Yeah, but they make a case that if the EC goes down, that also affects the election results. And obviously, there are parties to that one. Must they sit by and watch you make a case that will defeat what EC has done? Says, okay, let's turn this whole thing that's what obviously.
You see, I see your point. If the EC goes down, if the case of the EC collapses, it means that something else will be done which will be, will be inimical to their interests or to affect their interests adversely. I agree with that point. But you see, all the EC, this beyond this petition, the EC as an institution is going to be there. Do you know that? Sure. It's going to be there. Now, if EC is perceived after this case to be for a certain particular party, the consequence of that body, its credibility on the elections in this country, is going to be very detrimental. If the EC now, from their posturing and the way they are, everything concur and everything in the courtroom, the way they are going, and if people see, okay, so the EC now is the same more or less with the NDC. The effect of this thing, in the latter picture, is very serious. So, like my elder brother said, senior said, look, the EC is posturing to even those adversarial come in as an independent arbiter, come and state the facts, the truth. You see, if you are telling the truth, it's so simple, it's so easy. You see, you flow easily. But when you are trying to be evasive and you are trying to lie, you struggle with it. But when you struggle with it, let me finish my point. Today you are cutting me too much.
But what I have to work.
When you struggle too much, I'm not saying so. I'm just saying that. You see, when you struggle too much, and you become evasive with your answers, you give ammunition to the petitioners, and in the cross-examination they will bash you very hard. But when you come and at the end of the day you are just truthful and honest and frank in your dealings, like the way you started, it happened here. They say no verification, no vote. You said it. He said the person has not heard it anywhere. That no verification, no vote. Until the tape was played. He said he has not heard it anywhere. That no verification, no vote.
Until which tape was played?
Until his tape on City FM was played.
No, but he was talking about someone else making reference to no verification, no vote, not himself.
Someone who is the someone else?
Oh, but if who is
the someone else?
Would you fault it?
Who is the someone else?
Said something somewhere.
You see, you come to a court of law. When you get the court of law, the court is there to look at whatever has happened and find out whether you see this whole trial. I have a different perspective about it. You see, the court is trying to find out exactly what happened. These allegations by the petitioners, are they indeed true? Did it happen? No verification, no vote, did it happen? Same serial number, did it happen? People voting, overvoting, did it happen? You see, so you the EC who conducted the election, who was paid by the taxpayer and donors' money to conduct the election, once you are in the box, help the court to find the truth. But you should not be seen or perceived to be on one side. If you are seen to be on one side and you are aiding one side, what happens is that after this case, the ripple effect on the society is that, as for EC, they belong here. And that is very detrimental to the image of the EC as an institution, not as Afarijan. The image of the Electoral Commission as an institution, because the Afarijan now represent the embodiment of the Electoral Commission. And his acts, everything that he does in the box there will also be, just a with the...
But you expect anything different? I mean, if he's declared someone winner, and you're challenging that, and the person has come to say, well, I think that you declared me winner on fair grounds, so I go along with you.
You see, look at what he himself said. He himself said in his own evidence in chief. You see, I don't want to put in so much fire in this matter. Else, you see, they are listening to us. They may also go and make certain adjustment here in the cross examination. But he himself said here. He himself has said here. that if he is notified of any problem, in the elections, whatever it is, he must do an independent audit for himself. But let's not forget that the party chairman, Jake Otanka Obechebilapte, called on him to audit the machine and also do a recollection of the entire 26,002 polling stations.
But he also said that was actually going to be an exercise that would have taken less than a month. What are you expecting?
Well, so subsequent to that, has he done it? He only come and said, look, until the petition was filed, I was not even aware that certain places in Nairobi were even unknown. How? That you were not, until the petition was filed, you were not aware. So you the EC, but you are not in control of your own work. Henry, Gary,
I think we are in. Let's do 10-10 quickly and we'll go 10 seconds. Just
Harry, thank you very much.
That this perception about the fact that now, like the EC is more DC sort of.
No, like I reacted to how Doctor put it. I think that to us the EC is being fair. There are certain instances that is indicated. Like he's able to say that this is irregularity. He stated it. With regards to biometric verification, overvoting, he stated that
that's an issue.
So that's fine. But then you see the point.
Yeah, they are.
The point about saying that 9th December he went to the EC, telling the EC to cause an audit of the BVDs, and now we are in court. We want to bring the BVDs, and you are escaping from it. Let's go
to call with Kamau. Sure, stay with us. Doc, tell us what it means now they are on break. There's an issue at stake now.
Quite clearly, you can see that the EC Council is not up to the tax. Excuse me to say. So we realize that my advice earlier. Now the NDC Council, Tonlita, and then Tonlita the President Council, and then Chatu said, look, they sing together, and they've sat down for the first thing to happen, where they did not, their voice were not heard, and then Addison was able to overcome Kwashiadan, and then they couldn't get their way through. The document was rejected. This time, Kwashiadan wanted to tender another document, and then at the same time, they have rejected. So that is the situation. They have generally realized that look, it's best now for us also to speak on the issues, because at the end of the day, will be also affected by any rejection or admission of these documents. So at the end of the day, we realize that one of the judges, I don't know, the female judges, posed the question: please, are you not satisfied with the objection, the response that Kwashiadan have made against
the
objection? And then that shows clearly that the first and third petitioners now do not have so much confidence. Yes, respondent do not have so much confidence in the second respondent, and they think they have to come to his aid. But I'm surprised, because when it comes to Asedun Ketia, we have the two lawyers joining and then Chachu leading. By this time, they want to go their separate way, and Philip Addison is not comfortable. He said that, look, I am dealing with the second respondent. Please stay. Don't come in. And he said, we also come in. So that's the situation. Now they have confused. You realize that the coming in of Chachu and Lita has forced the bench to go on recess, because they are also raising serious issues now.
Let's ask. Let me find out. Yes, Addison can raise objections to questions he finds leading as far as the EC's council is concerned. Don't you think that in some way it's also possible that the respondents, first and third, could find at a point in time questions that might also be leading questions to them, which they think might elicit answers which might not go in their favor? So they also have a
you realize that the issue has taken.
I don't know if I've made myself clear.
They are not too much worried about leading. Or leading questions, the objections, you can just withdraw the questions. But they are worried now about tendering of certain documents, register.
Okay.
And then to them,
which now is being quoted as a primary source of,
and to them they have left evidence as to the number of people in the register, and then they think that if this document does not go through, it will also affect their case. And they are pushing,
because I heard Chachu at the point in time talk about primary source of record not being the pin sheet.
So you can see clearly since morning what I told them about the EC Council.
He needs help.
Yes.
So Chachu and Tonlita will join the battle.
Well,
what does that make for you?
I don't think so. You see,
that is if it is ruled on.
You see, because we are awaiting ruling, I will not go into the merits of the matter. But what I'm saying is that you see, I don't think that Mr. Kwasi is not up to the task. I don't think so. You see. There has been an earlier
to say anything.
There's been an earlier ruling on this particular matter.
Okay.
As whether or not the other councils can respond to questions or objections when it's being put to a specific party. You see, this is an objection which has been put to Mr. Kwasi Aidan. And the difficulty we're having here now is that there's been an earlier ruling on it. That because the matter relates to a specific party, that party is confident to deal with the matter. But now what is happening is that we have Mr. Lethe and Mr. Chachike trying to jump into the defense of Mr. Kwasi Aidan as if he's not competent to do his work. That's the way I see it, but I don't think so.
Just to give him moral support.
Moral support for what? Moral support for what?
Especially to think of it that they have made most of their submissions and case premise on what he's trying to push through now.
Henry.
And so if that falls, then how strong would that also fall?
We have each of the parties in this matter is a distinct party in itself. MDC is a distinct party. EC is a distinct party. President Mahama is a distinct party. All represented by different lawyers at every point in time.
Fighting for the same cause.
The same cause, but they've all been served differently. They are all different parties. You understand? So I mean, Mr. Aidan is a very seasoned lawyer. He can do his job. So I don't see why they are now jumping in the fray as if he can't do his work. That's the way I see it. And there's been an earlier ruling on this matter that no, when the matter is put to a specific council in the matter, leave it to the council to deal with it. Now, I don't know whether they were listening during the break when Doc was making those submissions that they might jump into the fray. Now it appears that they are now jumping into the fray. I don't understand. I don't understand because Mr. Aidan is competent to do his work. I mean, he's been doing his work all this while. So why this eagerness and to jump into as if he can't do his work? That's the way I see it. But he's doing his work confidently and competently. So why? Why? I mean, what do you say when you fall together? So you will make sure that at least whatever it takes, you will still jump when the question is not even put to you to answer. The question is in respect of a document seeking to be tendered. That is the primary. What they call the register. The register. Okay. And there's an objection being put to it that look, you can't tender this register. So why don't you let the man? And he has answered the question. So the judge said, "Are you saying that we are not satisfied with the answer he's giving you, or what?" And me, I was satisfied with the answer Mr. Aidan gave. So why this haste manner of others trying to jump into the fray? I don't understand. Me, Mr. Aidan is a competent lawyer to do his work. Okay. I don't understand.
What do you stand to lose or gain here?
I don't understand.
Why?
But Henry, I'm surprised the brother from the other side, the petitioners, who always put up their case that way. We all know that fundamentally, finest lining in law is the principle of syllogism, logical conclusion. The point he made clear. What do you mean by fall together, rise together? In pleadings, or in the CI for the proceedings, we have joinder of parties and joinder of issue, which is tried knowledge. And when that joinder of parties apply in law, in civil proceedings, like you said,
they should be granted.
The point is that
we're picking up signals.
Of course. So the point is that Chachu knows that our interest is affected.